Well, good morning and welcome to this Eversheds Sutherland PROPcast. My name's Joe Ging. I'm a professional support lawyer to the real estate team here at Eversheds Sutherland. Well, our topic today is the contractual controls regime, and that will be coming into force fully on the 6th of April 2027. This has been developing for a number of years, and it follows consultations that have looked into the benefits of the regime and how it should operate going forward. The government has recently published draft regulations and accompanying guidance, and the regulations have been laid before Parliament. Now, the regulations are in draft and they've not yet been made, but there's every expectation that they will be, and they will come into force, as I said, on 6th of April 2027. I'm going to start today's session by giving an outline of the regime. We'll then consider the concept of a contractual control, and then after that, we'll look at what information this new law is designed to capture, and the triggers, the deadlines, and the penalties that are being used. Now, as you'd expect with something as complicated as this, the regulations go into quite a bit of detail, and in some parts they are open to interpretation. So this is going to be an area of law where understanding and practice really will develop, both before and after the law comes into force. So it's the sort of thing where it's going to be really quite important to maintain a watching brief. So, having done introductions, let's now take a look at how the regime is designed to operate. In very broad terms, the regime means that if a landowner enters into certain sorts of agreement to sell or lease land in England and Wales to a third party, and the purpose of the agreement is to facilitate development, the third party will have to provide the land registry with specified information in relation to that agreement, and that's all as long as the right is held for the purposes of an undertaking. Now, examples given for an undertaking are business, charity, and the exercise of public functions. And most of the information provided will then be publicly available. The very broad policy objective is to increase transparency in the land market. But what does this mean? Well, the sort of arrangements that will be affected are not of themselves anything new. As we'll come to see, they are tried and tested contractual arrangements that have been used between landowners and other parties for many years. And these things are often protected by way of a unilateral notice and a restriction placed on the landowner's title. Now, whilst those entries might give a sense of what land is bound by what sort of arrangements with which sort of parties, the government feels that by increasing the amount and the availability of data, the public, local communities, and local planning authorities will all be able to better understand land use patterns, but also identify land which both has development potential and, crucially, is available. Now, these interested third parties can then better direct their resources away from trying to identify land that isn't already contractually bound to someone else and towards achieving development goals. We expect this to affect all sorts of organisations involved in all sorts of development, and this could be house builders, land promoters, developers of logistics and data centres, and many others. The rights that a person has over land are referred to as contractual control rights, and the information that they will be providing is called contractual control information. So now that we know how the regime broadly operates and what its aims are, we can have a little look at some of the detail. The key question is, what is a contractual control right? The main sorts of agreements and rights that we're concerned with here are options, preemptions or rights of first refusal, conditional contracts, subsale agreements, and also promotion agreements. But as you'd expect, there are very detailed rules that will have to be applied to show whether a right in one of these sorts of agreements is or isn't subject to the new regime. So broadly, these are: the land has to be registered, the right must oblige the landowner to make a relevant disposition, and the arrangement must not fall into certain exempt categories. Right, taking these in turn, the first thing to watch out for is if the land you're looking at is unregistered. If it is, it's going to fall outside the scope of the regime straight away. Whilst most of the land in England and Wales is now registered, it's still quite common for developers to come across unregistered land. That's especially when you think that a lot of prime development land for housing estates and other major developments may have been in agricultural use, so it might not have changed hands for a long time, so it's not really been triggered into first registration. Next, The right must oblige the landowner to make a relevant disposition. A relevant disposition is a transfer of the freehold or the grant of a lease of more than 15 years. As developers spend significant sums of money on the land, but often even more on planning and building out developments, they need to secure a sufficiently long interest in the land for the deal to make financial sense. So this feels like a fairly low bar, and it will make sure to catch or exclude the sorts of development that the government seems to be interested in. Finally, we have exempt categories. If a scenario falls into one of these categories, then it will fall outside of the rules and no information will need to be provided on it. These include rights which are linked to a loan or a financial instrument, contractual obligations to pay consideration, so things like overage, and those where there's a total period of control which is less than 18 months. For example, if you had a usual sale and purchase agreement with a standard 28-day gap between exchange and completion, it wouldn't come under the regime. And the exempt categories is also where you find the provisions which are essential to making sure that only developments in the usual sense that we use it in a real estate context are picked up. The draft regulations set out a test which is to be applied to work out if any arrangement under consideration are contractual controls for the purposes of the regulations, and so might trigger the obligation to provide information. The test sees future development as anything which may result in one or more dwelling house or a building with a floor space of at least 100 square meters. To put it another way, if you have a right in a contract that is held exclusively for purposes that do not relate to that sort of future development, so that's something other than development that will result in one or more dwelling house or a building with a floor space of at least 100 square meters, then it's going to be exempt. And there are more exemptions, but these are the key ones which we're expecting to see quite a bit of. Now, once a party has worked out that they're subject to the obligation to provide information, the next important question to ask is, what information do they have to provide? The approach that's being taken is that the document itself does not have to be submitted. Instead, the regulations specify a broad range of information that must be provided. So things like the names of the parties, the type of contractual control rights that's been granted, details of the land that's bound by it, they're all fairly straightforward. But there are a few more complicated data fields that are going to have to be populated. And these are things like any conditions that must be satisfied before the disposition goes ahead, and also the period of control. Now, it's common for development contracts to have different extension periods or long stop dates depending on the matters that have arisen. So this is something that will have to be really carefully looked at. Under the draft regulations, the information will have to be submitted to the land registry online, and it must be submitted by a conveyancer. The use of conveyancers to submit information is unlikely to be problematic for many of those affected by the new rules, as they will already have lawyers acting for them in relation to the transaction itself. However, we're going to see a little bit later on that there are also obligations when a contractual right comes to an end, and this might be where that logic doesn't necessarily carry. There is a further point to mention about the information that's to be provided, and that's something said that does not have to be provided. The regulations do not require the provision of financial information in relation to the deal. If it were otherwise, it could have been quite a concern for many developers and promoters who often enter into these sorts of agreements as part of a land assembly exercise, where, of course, value paid can be extremely commercially sensitive. We've now covered what are the main contractual control rights that are subject to the regime and the information that has to be provided about them. So we're going to move on to what actually triggers the obligations. The first group of triggers relate to the grant and the ongoing life of the contractual control arrangement. So these are first the grant of a contractual control right, and this is the obvious trigger that will be at the forefront of people's minds when they're thinking about this new regime. It'll pick up the usual entering into of an option or a preemption agreement or other relevant agreement that, all other things being equal, is caught by the rules. Secondly, we have the trigger which may require the most thought, and that's a written variation that alters the contractual control information and either information has already been lodged in respect of the right, or the right counts as a contractual control right, so something that is caught by the regime, and that's at the point of the variation. So we've got three components to this variation trigger. The first is that the variation must be in writing. We'd always expect this to be the case. There might be some circumstances where perhaps a party seeks to argue there has been a variation even though nothing was written down. But in the commercial development world, we would generally expect everything to be formally documented. Of course, that's in accordance with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. The second component is that the variation must be varying the contractual control information. So that's the information that has to be provided about contractual controls. This might perhaps be something pushing back a long stop date, or maybe altering a condition around planning permission where the LPA has indicated something needs to be changed. And these are the sorts of things we see quite a lot in practice. So parties are going to have to bear in mind this additional step that has to take place when they're carrying out one of these transactions. The third component is that the contractual control right either must count as one at the time of the variation, or is one where information has previously been provided on it. So, for instance, if the parties exchanged on an option agreement after the regulations come into force, they'll then have to have provided contractual control information about it at that time. But if the planning process has taken a bit longer than anticipated and they now need to push back a long stop date, a variation to the option agreement to do that pushing back of the long stop date, that will trigger an obligation to provide information. So there we have grants and variations. But the third trigger is the assignment of a contractual control right, where it was a contractual control right at the time of the assignment, or where contractual control information has previously been provided in respect of it. And this is the same sort of wording as the final component we talked about with variations. In particular, this will mean that parties will have to be alive to the status of rights that they're assigning between group companies, or perhaps where one developer is taking over from another. That's the first group of triggers, so grant, assignment, and variation. So they're all at the beginning or during the life of these arrangements. Now, the second group of triggers all relate to the end of one of these arrangements. The grantee of a contractual control right must inform the land registry when the right is determined, expires, or is exercised. And these rights, or these triggers, apply on partial determination, expiry, or exercise, as well as whole. So many development sites will have phased drawdowns, which will mean a submission is going to have to be made to the land registry on each of those drawdowns. Now, this is going to be administratively onerous, but at least the parties will have more of an active role, which will prompt them to make the necessary submission. Where things could get a bit trickier and a trigger becomes easier to miss would be where one of the arrangements is just allowed to lapse. Parties are going to have to put in place robust tracking and monitoring processes to ensure that nothing gets missed and to ensure lawyers are instructed in good time to avoid missing any deadlines. And that's what we're going to be looking at next. The deadlines to provide information to the land registry are going to be really quite important. This will become evident when we look particularly at penalties later. In earlier consultations around the contractual controls regime, the government were looking at the regulations having retrospective effect, so the parties would have to provide information on arrangements they'd entered into as far back as 2021. This would have been an extremely time-intensive and costly exercise for many developers, so many will be pleased to see that it has been dropped. Whilst there is no retrospective effect with the current regime, there are nuances in the transitional arrangements which parties really will have to be aware of. The transitional period is the period between the regulations being made and them coming into force. We know that the regulations will come into force on 6th of April 2027, but the date that they will be made is an unknown. In terms of when this transitional period will commence and what is meant by the regulations being made, the government guidance explains that this will be once the parliamentary process has been completed and the relevant Minister of State signs the regulations. This is expected to be in the first half of this year. The reason this is relevant is that contractual control information must be provided on any rights which are granted during the transitional period. So between the regulations being made and 6th of April 2027. And the deadline for providing that information will be the 6th of October 2027. Different rules apply when one of the triggers happens after the regulations come into force on 6th of April 2027. If any of the triggers happen from or including this date, so that could be the grant, the assignment, or the variation, which I mentioned earlier, the information must be provided to the land registry within 60 days of that trigger event. There's something really quite important to bear in mind with these deadlines. They do appear relatively generous in allowing quite a significant amount of time following the trigger event to provide that information. However, this relates to one of the practical ways in which the government is seeking to ensure people comply with the regime. The usual way to protect something like an option, a preemption, or another sort of agreement which we tend to be dealing with under the contractual controls regime is to register a unilateral notice and a restriction at the land registry. Now, this practice is going to continue because the contractual controls regime will not give any form of protection should the land change hands. But the regulations make clear that the land registry can refuse to register a unilateral notice or restriction if they think it relates to a contractual control right and they are not satisfied that the information has been provided in relation to it under the contractual controls regime. But what does this mean from a practical perspective? It's always important to lodge applications for unilateral notices and restrictions promptly. So as a result of all this, although parties will have these significant periods to provide contractual control information, they will inevitably lodge it much sooner to ensure that they can also secure the protection of their unilateral notice or restriction. I mentioned earlier how there are also triggers to provide information on the determination, expiry, or exercise for contractual control right. And the basic rule is that a party must notify the land registry within 60 days of this event. There are some nuances around this, such as what would happen if an agreement is varied or assigned and then immediately exercised, but we're not going to go into that level of detail here. I've talked quite a bit about what the obligations are and when they're triggered, so I'm now going to turn to who has to comply with them and what happens if they don't. The person who has to provide the relevant information to the land registry is called the grantee. In most respects, this is the person who can enforce the contractual control right. And there's a slight widening of this definition in specific circumstances, and that's where you have a person who isn't themselves a party to the contract containing the contractual control, but they're able to direct or request another person who is a party to enforce it. And an example of this would be in a promotion agreement context. The promoter is able to direct the landowner to transfer the land to as yet an identified third-party developer. The incoming developer, of course, they're not a party to the contract between the promoter and the landowner, but the developer will be able to direct the promoter to enforce the contract with the landowner. And it's those sorts of circumstances that we see the widening come into play. But turning back to the obligation to provide the information, well, what happens if the grantee fails to comply with its obligations? I've already talked about one of the practical consequences, which is the land registry refusing to register a unilateral notice or a restriction. However, the Levelling Up and Regeneration Act 2023, which is a piece of legislation which underpins the contractual controls regime, contains criminal sanctions for a party who breaches the obligations. There are two offences. The first is if a person fails to provide the required information without a reasonable excuse. And the second is where a person provides false or misleading material and either knew that was the case or they were reckless as to whether it was. The penalties for these offences are fines and imprisonment, and it goes without saying that they're to be taken really extremely seriously. Of course, in any commercial context, the grantees of contractual control rights will normally be companies, joint venture vehicles, or partnerships. The legislation in this area states that if an entity commits an offence, then in certain circumstances, a person who is a relevant officer of that entity may be taken to have committed the offence themselves. The Levelling Up and Regeneration Act provides some examples of relevant officers. For a company, this might be a director, manager, secretary, or a similar officer. For a partnership, this would be a partner. And for a body corporate or another incorporated body, which has itself a governing body, it's going to be a member of that governing body. The liability of a relevant officer comes up if they're the person who authorizes or permits, participates in, or fails to take all reasonable steps to prevent the commission of an offence. This again highlights why it's really very important for organizations to have very clear and robust processes in place to ensure that they understand and comply with all of the relevant obligations. I'm now going to look at a few suggestions as to things that organizations may wish to consider as they prepare for the contractual controls regime. Looking backwards, organizations may wish to consider what contracts they already have in place and whether they may need to carry out any variations or assignments of those rights in the future. The deadlines proposed by the coming into force of the regulations may mean that such transactions are pushed up the list of priorities so that they can complete prior to them being subject to the regulations. In terms of the here and now, the first thing to do is to work out if the contractual controls regime is going to affect the deals that you're involved with. There will always be exceptions and each new transaction will require a fresh look, but you may find that the sort of matters that come across your desk may not be picked up by the regulations. The other point to consider is around any negotiations currently in flight. And businesses may want to push to ensure that these complete prior to the regulations being made so that they're able to avoid the implications and the obligations should the contractual control right be granted following the regulations being made. As I mentioned earlier, we don't have a set date for the regulations being made, so it seemed that parties must really just seek to complete these sorts of things as soon as possible. Then, looking forward, there are two broad actions that really come to mind for me. And the first of these is to put in place those robust processes to really ensure that all information is properly recorded and any obligations are met. I said earlier how transactions involving the grant, variation or assignment of a contractual control right may be easier to spot, as that will become part of the baked-in process for those particular deals, and there'll usually be lawyers involved acting for the grantee on the deal. However, what is going to become trickier is ensuring that deals which expire are not missed. The second action is to consider whether there are any other ways in which transactions can be structured. This may be because the information that grantees would have to disclose is particularly sensitive, or perhaps they would rather it didn't make it into the public domain. Or also it could be part of a risk mitigation strategy, and this is to avoid the potential breach of the obligations under the contractual controls regime. Of course, changing the structure of a deal may have tax, planning, other consequences, which will have to be factored in and looked into in detail. But what we may start to see is that some developers looking at alternate ways of proceeding with this all in mind. Before I bring this PROPcast to an end, I'll just recap the key dates. The first is the date on which the regulations are made, which is currently not a fixed date, but it's sometime in the first half of 2026. And this will mark the start of the transitional period. The next date is 6th of April 2027, which is when the regulations come into force. From that date, all of the rules apply when it comes to grants, assignments, variations. The final date is 6th of October 2027, which is the deadline for providing information on rights granted during the transitional period. That brings us to the end of this Evershed Sutherland PROPcast. Thank you very much for listening.